Okay, so what you're going to do here is we're going to mark dissolution of marriage. This is a judgment for dissolution. You're going to have, in our cases, we're handling uncontested amicable divorce cases. So you're either going to have a default or uncontested, and this would be default with agreement or true default. That would apply in any case here. The next important box to check is respondent was served with process as far as the court acquired jurisdiction of the respondent on. And you're going to enter the date here. Now, this can be the date they signed the notice of acknowledgement. This can be the date that they were served by personal service. And the other alternative is if the respondent filed a response instead of being served, the other thing you can do is mark the respondent appeared. That's what it means to respond. The respondent appeared, and then you'll enter the date that occurred on, that the date the response was filed. Then you're going to mark box 4A, the court order's good cause appearing, and you're going to mark on specific date. You're going to leave this box blank. Do not fill this in. It'll cause your judgment to be rejected. The court will actually fill this in, and the date they're going to enter is going to be the date of the soonest of the 6 months and plus 1 day of the date of service, or if it's been beyond the 6 months, it'll be the date that they actually process your divorce. None of this is ever required. We never needing to complete any of this. If there are minor children and there's a child support order, you're going to mark this box here. All right, let's go to page 2. As far as this information here being, last name, first name, we're just entering, one of the parties' names in here. It's never been an issue. So in this case, who we have Jane Smith. So you can just do Jane Smith. This is really not an issue, but you just want to have one of the party names on here. If there are minor children, you're going to want to indicate that here, put their names, and you're going to want to list their names exactly how you did on the petition. So just make sure that matches up, and then date of birth. One important thing with the judgment is if you've had children born prior to the marriage, you may have noticed on the petition when you filed that they asked you to attach the parentage or declaration of parentage. If you didn't do it then, you definitely need to do it now, and you'll say, you're going to mark this box since it says parentage is established for children of this relationship. And then on one of the other forms, I'll show you where you attach that parentage form if you did not do that in the judgment, in the petition. Now, if you're just joining us, if you do have questions about how to complete your judgment, we have a couple of people on here. Feel free to ask in the comments or the chat, and I'll get to them at the end of the show when we've gone over all the forms for the judgment. Okay, if there are children involved, you're going to have to mark the child custody box. And we always recommend that you simply use the attachments that the courts give you. So in this case, the FL 341, and that'll be another form that we will be going over. If there are children, you obviously have to address the child support. What a lot of people make mistakes on is if there is, maybe they don't want to have child support in their divorce case, they're thinking, well, I just don't attach this. You need to have a child support order, even to say there is no child support. And I want to make a comment about this settlement agreement, stipulation for judgment or other written agreement that you see as the first box in most of these. At the end of this, I'm going to show you how, if there's additional information you need to include that it does not have room in some of the forms, I'm going to show you the marital settlement agreement format you can use, and or just to have a place to sign. One of the biggest issues clients, not our clients, but people that are trying to get through divorce, they say, Tim, where do we sign? There's, we have this agreement using the forms, but there's nowhere to sign. So it can be a problem, and I'll show you how to fix that. Spousal support order. Another mistake people make is they say we're not having spousal support, so they don't attach anything. You still need to have the order. And so you're going to, again, we're saying use the form FL 343, and the order does need to be attached to this. This 180 is kind of like your face sheet. And so you will have in all cases, you're going to have to attach this form. And you're also going to indicate up here, what is the plan? Are you guys reserving jurisdiction and not, so that means you're not going to have spouse support now, but maybe in the future? Are you terminating spouse support to both parties? So you're going to want to mark at least number 1 and number 3, or number 2, and number 3. as far as having spouse support. You're going to have this in all cases. And then you're always going to have a property division order. And again, it's just easiest, especially if the property is minimal, you can fit that right into the spaces they give you on this 345. So at a minimum, if there's no children, you just are going to have the spousal order and the property order. I want to make that clear. When you're done with all the forms, you're going to count them up, and all of them beyond this page 2 of the 180, that is where you're going to enter how many pages you're here. And that's how you complete the 180. The next form we're going to talk about is the 190. This is another mandatory form as part of your judgment package. Very straightforward form, very easy to complete. People still make errors on them because there are some boxes here you're wondering what you may have to fill out. So I'm going to go over this with you. Okay, you are notified that the following judgment was entered on. You do not enter a date here like the 180. The court's going to enter that date. You're going to mark the dissolution box. You're not doing status only. Status only is when you're only doing the divorce and you're not doing assets, debts, custody, etc. So it's 99% of the time, it's always going to be dissolution. And at the bottom, nothing in these blanks here, but you do want to include the names of the parties and the addresses the court has on record. And that's it for purposes of the 190. If you have minor children, here is the child custody order and visitation order attachment that we were referring to using when doing your judgment and there's children involved. You always need to have a custody order involved if there's children. So here's how you complete the FL 341. This is going to be an attachment to the FL 180. Remember, we just showed you, here's the 180, and it's going to be a cover sheet. That's how that's used. And the 341 is an attachment to that 180, as are all the other attachments. Now I'm going to go through the most basic way. Remember, we handle amicable divorce cases, so there's not a lot of complexity in the settlement agreement. So I'm doing this in the most simplistic terms and the minimum standard that you would need to provide the court when doing a custody order. Country of habitual address, you're going to mark the United States, and you're going to mark child custody. So child custody of the minor children of the parties is awarded as follows. So in this section, all you need to do is enter the names of the children. So we'll say Eric Smith, going to put the date of birth. And then for custody, the only thing you have to include here is to say joint. Joint. That's as simple as you can provide the court. They don't need anything additional to that if you guys just have a simple joint legal, joint physical custody. Now, of course, if on your petition or you guys do agree that legal custody will be to one part or the other, then you can just enter the name there. But I'll tell you, we've been doing this 10 years, and 99% of the time, we are simply doing joint legal, joint physical because our clients are that amicable. And you can see there's a whole bunch of other boxes here. History of abuse, we're never dealing with that because of the nature of what we do. The only other box you guys are going to have to check on page 2 is this visitation. Reasonable right of visitation to the party without physical custody. That's all we are doing in most of our cases. I'll just show that real quick to you. We're marking joint for custody. And for page 2, we're marking visitation, parenting time, reasonable right of visitation. And that's all the court needs. You don't have to have a parenting plan. You don't need, just because these boxes are here, you can fill them out. Doesn't make it wrong. But 99% of the time, our clients aren't electing to do this because they're amicable enough to figure out when they want to have their children and timeshare on their own. It leaves you some more flexibility, and you don't have to do these. So that's what I just want to convey. None of this is required. They also have a bunch of other attachments that you can include that also are not required. So you have visitation here, that you do not have to include this. Transportation, you do not have to include that. Travel with children, you can leave all of this blank in the most simple cases. But again, it's not wrong to complete it, but it's not necessary. Holiday schedules, additional custody provisions. So they have all these additional forms, 341C, 341D, 341E. None of this is required. It's only required if you feel it's required or you want to include those. And then these forms get into more detail where the holiday schedule, you can select which holidays you guys want. But again, we're not really doing these. Maybe 1 out of 100 cases, the parties will want to include a holiday schedule or additional custody provisions. You don't have to, you've already marked joint legal on page 1. So again, none of this is required. So I just want to convey this to you. Joint here for legal custody and physical custody. mark the visitation box here, and you're done. That's all you need to do on this form unless you want to include more information. And that's it for the 341. Moving on to the 342, again, this is if only, obviously, if you have minor children. I'm going to show you the minimum standard of what you need to include here as far as submitting this form as an attachment to your 180. So again, it's going to be attachment. Okay, remember these are attachments to the judgment, FL 180. And with our clients, you always have to attach a child support calculation. So when we mark this box, it says here, I believe this is the line, it says, okay, a printout of a computer calculation. They're talking about what's known as a child support calculation or a DissoMaster calculation. It's required. You can't submit this without. A printout of the computer calculation and findings is attached and incorporated into this order for all required items not filled out. So what that says in English is if you do the child support calculation, which we have to supply the court because they need to know what the guideline child support amount will be, regardless of what you guys agree to. If you, by clicking this button and attaching the form, and all we do is attach the child support order right behind this form, you don't have to fill out any of this. All of this can remain blank. This is only when there's not a child support order attached. The next box is child support. So in the most simplistic way of doing this, you're just going to indicate who's paying who. The petitioner is going to be paying the other party. Beginning, you do have to put a date in here. So we can just put a date in here. What are we on? 23. Just making up a date here. Child's name, date of birth, monthly amount, payable to. And you would put obviously the other party here. And then how you want that to be paid. Half on the first, all on the first, whatever you guys decide. I'm going to be doing another video about how to set it up when you don't want there to be child support. I wanted to make this for a simple, yes, we're having child support and this is how we're doing it, because I didn't want this video to be too long uncovering this form. So look at our channel for another video on specifically when you want there to be no child support, despite there being an amount that the state says there should be on the calculation. Okay, page 2. I'm going to show you only what you need to complete here. The courts are making this required in most cases, not all the courts, but we are doing it now as a practice because they are using the word mandatory now on these, and the other ones were not. But on these forms here, if there are minor children and you're completing this form, we're just simply putting in 50% to either party. If one of you wants to do 100%, that's fine. But these two sections, 6B and 6C, we're seeing the courts wanting these to be done in most cases because of the use of the word mandatory. This non-guideline order, let me just discuss this for a minute. And this will be more about that other video I was referencing in regards to if you don't want there to be child support or you want there to be more or less than the calculated amount. That's what this non-guideline order means. But for purposes of this video, we're talking about a simple divorce case where there's an agreement to child support that matches the guideline amount. Healthcare expenses, what we're normally just marking is both boxes because if you guys want to switch at some point on the healthcare expenses or who's providing the coverage, if it's just one party and that's always going to be the case, you can just say whoever's doing that now. There's no right or wrong reason here. We're not ever completing B and C. This is not required. I'm going to move on to page 3 so we can get through this. Nothing that's ever required here. Other orders, if there's something that wasn't covered on page 1 and 2, you include here. But again, we've been doing this 10 years, thousands of cases, and we've never had to use this box. All right. So we've covered, we'll go back to the 180. We've covered the child custody order, and we've covered how to do the child support order. And if you're just joining us, I see we have a few people online. Feel free to ask some questions in the comments, and if you have some specific questions regarding your case, your paperwork, go ahead and enter into the chat, and I will answer them at the end of going over all these forms. So we've handled the custody, we've handled the child support order. Now we're going to the spousal support order here. And that's the 343. Okay, spousal, domestic partner, or family support order attachment. Again, attachment to that 180 form I just showed you. And here's all you need to do here. The parties stipulate just means agree. Then all you need to do is go to page 2 and indicate what you guys are doing. So you have some options here. Are you reserving jurisdiction for future determination, meaning no support now, but maybe some later? You would mark these boxes. And then you're done. This form is done. If that's all you're doing, there's nothing on page 3 you need to do. You're just saying The jurisdiction is reserved for future determination. If you are not going to have spouse support now and don't want it ever, and you mark that on your petition, then you're going to mark the court terminates jurisdiction over the issue of support for the petitioner and respondent. And then again, this form is done. It's that simple. I know there's a lot of on here and a lot of other options, but they're not required. Um, Now, if there is going to be spouse support, then you're going to say, what is that going to be? So if we're saying, for instance, petitioner must pay to the respondent, and is it going to be for a set period of time? Then it would be temporary. If it's going to be until further court order, we would say permanent. Then you're going to mark spouse support. So let's say we're doing temporary spouse support. So the way this reads is petitioner must pay to respondent temporary spouse support. The following month, the following amount, each month, we'll just say, $1,000, put the date it's going to begin. And this doesn't really matter. Just make it, maybe use a date that's a month or two from the date you're doing the paperwork, but it doesn't matter when that's going to be, unless you're using that date for a period of months. So if you're saying it's going to start on this day for 24 months, then the date matters. But for taxes and so forth, it's not a taxable event anymore, so that doesn't matter. And then again, since we are doing temporary, we're going to say payable through, and maybe we're paying, for 1 year. And then again, you want this paid on the first day of the month, 15th day on the month, or maybe you want to say something like half on the first, half on the 15th, something like that. You could, however you guys want to set that up, or on, matched up pay periods or something like that, however you guys want. Support must be paid by check or money order, and that's fine, unless you want some other method. Earnings assignment order. This isn't required, but this form has been updated. So we're selecting one or the other. The earning assignment order means, do you want the money withheld from your employer? Most of our clients, again, 99% of our clients, do not want the money withheld from their employer, not because they're not going to pay it, but they just don't want their employer knowing that there was a divorce, because you'd have to give them a copy of this order. So in our cases, we're saying service of an earnings assignment is stayed. That just means stopped or not being provided. Provided the payor is not more late than 10 days. And so all that means is there is that option in the future. If you want to have a withholding order assigned to the case, you have that option if it goes beyond 10 days. Like maybe you guys were in agreement now and payment was always on time, and then now payment is not coming through and you want to have a withholding order. This gives you the option of doing that if it's late more than 10 days. Nothing else is required on this form. Again, everything else is optional. The nice thing about these forms is there's a lot of built-in information. All the legalese is already in here. And that's why we tell clients, don't use these marital settlement agreements you get online. They don't have the proper language. The courts is always updating these forms a couple times a year, not all of them, but some of them. And if you use some form you've Googled online, it's not going to have the appropriate language, and it's going to cause your judgment to be rejected. Again, none of this is required unless you want to, it applies to you. But if I haven't said enough in this broadcast that we're never doing this, and we've been doing this for 10 years. We're not having to fill this out ever. So keep it simple. All right. Another form that you must have, even if there is no property, no assets or debts, just like the spousal order, you still need this order. I'm going to go back to this real quick. The spouse support order, you still need this, even if there is no spouse support, and you just mark no spouse support terminating the court's jurisdiction. All right. Now we're going to go on to the 345. Pretty straightforward, and why I say use the forms. Pretty easy. They make it very clear. Division of community property assets. If there are none, mark none. If there are some, mark the box and put what your assets are. Maybe, you have a vehicle, 2011, what do we have here? Toyota Prius. A lot of those run around here. Put a comma and continue on with what the assets are going to be assigned to petitioner here. Same thing for respondent. If you're going to have a quadro, I can do a different video on this, but if you are dividing a pension, if one of you have a 401k or a pension, something like that, this is where that information would go here. You might want to say petitioner respondent will be, share the costs of preparing the quadro, and you would list the name of the quadro here, who's going to pay for it, or anything else you want to include regarding that. We also will always mark this box G here. Each spouse or domestic partner will receive the assets listed above as sole and separate property. The reason that's important is because this is the community property section. This is the assets and debts you guys acquired during the marriage. So that this needs to be assigned to you as your sole and separate property. Division of community property debts. So where this was just the assets, this is now just the debts. So again, either there are no community property debts, or the petitioner will receive the following debts, and then you'll list them here, kind of just like you did up here. And on page 2, the respondent will receive the following debts, and you would just list the what debts the respondent is going to receive. Never need to use this section. Equalization of division of community property. So this is used if you are going to buy out, for instance, your spouse out of the family home. You would say, petitioner will pay to the other party, I don't know, $50,000. And then you would say to buy out the community property share of the XYZ property. Separate property. This is a different section for everything else that's not community property. So maybe you had an asset, car that you owned before marriage that was paid off. You weren't making payments on it. It was a before marriage or after separation asset or debt that would go here. And you'll just list those separately here. Usually what we're doing is just to cover any other property that you didn't list on this form, because what we're telling our clients is you don't have to list, the silverware, the microwave, and get that detailed. Major assets, things of value, things you want to see as part of the marital settlement agreement. That's what you want to list. And then for this section, if it, one or two items, I would say you could list them here. But what we are saying is this: any and all assets and debts in petitioner's name or possession. And then we're doing the same thing down here, but saying any and all assets and debts in respondent's name or possession. So super simple. Sale of property. If you're going to sell a home, you can list the address of the house and you can say divide equally, or if it's going to be, some other division of that asset or of that property, you could say, I think a common thing we would use is petitioner to receive the first, $50,000 of the equity and remaining equity to be divided equally, something like that. Other orders, if there's anything else you want to include that there wasn't room for. What we're usually using this for is if on one of these other sections, maybe there's too much to list in this box. At the very end here, we'd say see other, and then we would say, continuation from 1A or something like that. So this are the forms you need to file your judgment. Now, I want to give you kind of a little bonus here where we talked about in the beginning where people are having problems about where do we sign, or what if we have more assets or more debts. I want to show you this. Let's see if I can bring this up. Okay, so if you have a lot of assets and debts, if you have some things that's just easier to include it as a narrative, you want to explain something, or something that makes more sense to you guys, you can use something simple like this. So this is not something I got offline. This is something we use internally, because if you noticed, going back to those forms, there's nowhere to sign at all. There's nothing to sign. So this is an attachment that we've just come up with. It has, just some fancy language about exclusive agreement of the parties. And then we just get right into it. We just have a heading for property division. Petitioner will receive as her sole and separate property the below listed assets, debts, and then we just bullet point out what they are. Same for respondent. Just keep it super simple, guys. Other orders. So if it's not an asset or debt division and you just want to include some narrative here, maybe it's how the house will be sold or just something that wouldn't just fit in here, include that. And then all you need to have here is, the signature line somewhere for the parties to sign. So approved as to form and content, petitioner's name, respondent's name, place for the judge to sign. And this is what will be the last pages of your judgment. Now, one last thing I want to go over is how do you put together your judgment package? You have all the forms now. Let me go back to sharing the screen. So you have all these forms. You have the 180, the 190, you have all these forms. Now, what do? Here's the order that these go in. You start with the 180, and then you're just going to go in order: 341, 342, 342A. We didn't cover that because that's going to be if there's a difference in child support. 343, 345. You just put those all in order. It's very simple. Then if you're using what I shared with you here, you would just include this behind all of that. And this would be your final page. And that's how you stack the judgment. It's very simple. And we had some comments come in. I just wanted to address these. Let's see what the question is here. What happens if you live in blank and don't mark anything regarding spouse support? Leave it blank. So I'm assuming you're asking about, let me change this here. What happens if you leave it blank and don't make anything, mark anything regarding spouse support? Do you have to check the spouse support box or can you leave it blank? So I'm going to assume that that was regarding the judgment form. I guess I will cover it on both possibilities. I don't know if you're still online, if you can clarify your question. But on the 180, I'm just going to read again. What happens if you leave it blank and don't mark anything regarding spouse support? You have to address spouse support in all cases. So if you've on your petition, you would have marked to terminate or that there is going to be spouse support or to reserve jurisdiction. You're just mirroring that here. So you need to mark one of these boxes here as far as spouse support, even if there's none. So what that would look like is jurisdiction terminated. That you would use this selection here if there's not going to be. So you're never going to want to leave this blank. The question was, what happens? Your judgment will be rejected if you don't address this. The other area is you do need to have this 343 attachment, and you're not going to want to leave it blank if it's just no spouse support. Again, the parties agree, and you would mark terminate. You wouldn't worry about any of this payment information. You just mark the court terminates the issue of petitioner, a spouse support for petitioner and respondent. And okay, hey, I'm glad you're still on. If I didn't answer your question, go ahead and ask me what that question is or if I've answered that. But you're always going to want to have a 343 and of course the 180, and you would not want to leave these blank because the court will say it was not addressed. So hopefully that answers your question. That is really all I had for you today. We covered the entire process of the judgment. Once you've put this together in the order I explained to you, you will have an original and then 3 copies if you're doing this by mail of these forms. The 190 didn't cover this because we skipped over it. This is a standalone form. This would be part of your final judgment package, but it would not be. Okay, I'm glad that I answered that for you. This would not be part of your judgment package with the 180. It's just a standalone form. Again, original for 4 copies. And you know what I just realized? I did forget one form, guys. Let me go back to it. You see there's lots of forms here. Again, we do this 5 times a day, and I'm still forgetting forms. Okay, let me go over. This is another mandatory form. We're going to talk about the declaration for default or uncontested divorce. So in this, you're going to mark dissolution. All the information in the petition is correct. Then you're going to tell the court what type of case is this. Is it a default without agreement, default with agreement, or uncontested? Our cases are default with agreement cases. What default with agreement means is a petition was filed, a response was not, but the parties have entered into a written agreement. We do that because you can save money on court fees. When you do file that response, it does trigger a second court fee. A lot of people are unaware of that. If you did have a response filed, then you would mark uncontested. Believe it or not, when a response is filed, that's what it means. That's what uncontested means. Both parties have appeared. The filing of the petition is an appearance. The filing of the response is an appearance. So, like again, we are usually default with agreement with our firm. Declaration of disclosure. What we're normally marking is this matter is proceeding by default. The declaration of disclosure was the income and expense declaration, schedule of assets and debts. You filed that with that cover sheet 140. And then you filed that 141 that had that long name. Declaration regarding service of declaration of disclosure. That's what you're saying is done here and that you guys have complied with that. Page 2, again, this is the box if there was uncontested, and you would want to match these up, obviously. So if here it's default with agreement, then you're marking in section 5 that this matter is proceeding by default. If you marked uncontested here, a response was filed, then you're marking on page 2, this matter is proceeding as an uncontested action. If there was child support involved, child custody involved, all we're normally marking is the information has not changed. Usually shouldn't. Again, we've been doing this a long time and we're not ever having to do anything other than this. Nothing in these boxes here unless it applies to you. And again, we're never filling that out. If there was child support, all you need to do is mark box 2, child information. The information in the child support calculation attached to the proposed judgment is correct based on my personal knowledge. And that's referring to the child support order that's attached to the 180. And this, again, we're not usually checking any of these except is not. If they apply to you, you can mark that you are receiving public assistance. Otherwise, you just mark that you are not box. And this might apply to you, Juliet. You had a question about spouse support. Another section you're not going to want to leave blank. I'm glad I didn't forget to talk about this form. Is, let's say we marked no spouse support on the 180, no spouse, terminate spouse support on the 343. One more spot. Tell the court I knowingly give up. I knowingly give up forever any support. I just realized I am not sharing my screen. Shame on me. You guys are looking at me, looking at my screen. Okay, I just noticed. I'm going to go back and go over this quickly, guys. I apologize for that. No one yelled at me on here saying I wasn't sharing my screen, so I kind of blame you. I'm just going to go back over this real quick, guys. I apologize for you looking at my face, up my nose, while I'm staring into the top of the screen here. Okay, declaration for default or uncontested. I'm going to try this again. Mark the default box. All the information in the petition is correct. You're going to mark whether it's default or uncontested. If it's default, you want to match it up here. The matter is proceeding by default. If you marked uncontested, which means a response was filed, you're going to mark the matter is proceeding as uncontested up here. Child support and custody, you're going to mark the information has not changed. Child support here, you're just going to mark the information in the child support calculation attached to the proposed judgment is correct based on my personal knowledge. Here's where I was talking about is not receiving public assistance. That's all you need to do there. Spouse support. Okay, back to this. I moved quickly through that because I'd already covered that. If you marked no spousal and terminate, you're also going to let the court know that here. I knowingly give up forever any right to receive spousal or partner support. If you are terminating, you're going to mark this box and you're going to say, I ask the court to terminate spouse support for petitioner and respondent. And you see how this all matches up with the 343 spouse support order and the 180. So this all matches up. And then you're going to mark spouse support or domestic partner support should be ordered as set forth in the 180, which we've gone over, based on a written agreement. So what is the written agreement? The forms 180 through 345 and then any other attachments you include, that is the written agreement. Because people will tell me, hey, I submitted our judgment, got rejected. They said they wanted a written agreement. What they've done is they've usually done this 180 and just marked these boxes and didn't attach anything to it. But they say there's no agreement to attach. All of these forms down here that you attach, that becomes your marital settlement agreement. So this is what it would look like if you wanted no support. I give up support, I want to terminate support, and we have a written agreement to that effect. Now, if you are reserving jurisdiction, and we talked about what that means, reserving jurisdiction means no support now, but maybe some in the future. You would say, I ask the court to reserve jurisdiction to award spousal or partner support. You'd mark petitioner and respondent. And then again, you'd still based on that written agreement. So that's going to be the two versions of that on the spouse support there. Parentage. So we talked about, and I had mentioned there's another form. When you file this, if there was a child born before marriage, what you're going to want to do is mark the parentage box, and you're going to want to attach a voluntary declaration of parentage. Now, my clients that are in this situation, I've noticed that they don't have this because it's probably been 5, 10, 15 years, however long or however old the child is. They don't have this form. So really all you have to do is come up with a Word doc and say, the parties agree that XYZ husband is the father of said child, date of birth, XYZ, and mother. And that really would cover it. You guys sign it and date it and attach it to this 170. Other than that, we're not dealing with anything else here. Um, if you are wanting to restore your maiden name, if you're the spouse, whether you're the petitioner or respondent, and you do want to restore your maiden name, you would mark this box. And if that was the case, I must have glossed right over that on the 180. You would also enter that here, petitioner or respondent, whichever you are, and then you'd put the name you want to restore that, which would be obviously your maiden name.